welcome back to Living Equity Podcast, you guys. Thank you for joining me. Yes, yes. Give yourself a round of applause for rocking with me this long. For those who are new to my channel, this is Living Equity, where ignorance of the law is definitely no excuse at all. And as we always stated, that one should know the law of the land in which they live to enjoy a better life, right? First and foremost, let's get some of this house chores out the way. I am not a law firm. Well, this is not a law firm. I'll keep saying I am, guys. This is not a law firm. I am not an attorney. This is for educational purposes only. If you need an attorney, I advise you to seek yourself a competent attorney that can assist you with your matter. Otherwise, this is entertainment, educational purposes only. And then, I feel like first and foremost, you don't have to be an attorney or a lawyer. There's a difference to actually know the law. I think if us as a nation knew the law pretty well, or at least some degree of it, a lot of our politicians will fall in line. A lot of things a little bit, will be better. The things we do, we won't be doing blindly, like voting, right? A lot of us vote blindly. What I mean by that is we vote basically based off our emotions most of the time, or what we heard they said they will do, without even looking into how government works, how would it get passed, what's the possibility of getting passed, putting block votes together where we get a collective of a group of people, maybe 20,000, 30,000, 50,000, what have you, and we all give our vote to this one particular person who promises that if they are elected, they will do X, Y, Z. These are some things, if you knew government or even law, that could better our situation as a whole. But of course, the boring things is not as pleasing to us. We like the oohs and ahs of information. We don't want to go through the struggle of the boring, learnings part of it. We want it quick, fast, in a hurry. I think AI is a benefit. It's also a detriment because it makes you lazy. It makes you not have to actually use your brain and go and research and dig. AI does it all for you. You just got to input the thought you're having or the question you have, and it does all the work for you. So not a full punch against in a black eye to AI, but more of us as a people to understand that we need to still be well studied, and we need to, of course, use AI in a way where it enhances what we already know. Now, it can teach you some things, of course, but don't let it be the only thing or the only way you learn is through AI. Go pick up a book, cross reference yourself, don't just rely on it, or after AI gives it to you, really do the reading, the detailed research, verify the AI's information itself. That's a good way to really make sure that you are learning what AI is providing to you from what you've entered. But this is part two. I'm going to put this as part two for our objections and how we appeal to a higher court. Last show or episode, we talked about appealing a jury and a non-jury's decisions, such as a judge's trial or during a jury trial, how we object and how their objections are preserved, and how is it a possibility we could have a review of a jury's decision, as the last video stated, and I'm not going to go over that again, but the hardest decision to get reversed would be a jury decision. There's ways it can be, but it's a lot more challenging. I'm going back to O'Connor's Federal Rules Civil Trials by Michael C. Smith. Okay. Let's see here. I think I left off at we talked about preserving the error. Okay. I'm going to start with preserving the error here. Let's see. Make it timely. We have our exceptions. Hey, but you know what? It's nothing like repeating yourself, is it? It's nothing like it. I might as freaking well, right? I might as freaking well. So let's go to error in weighing evidence. So this is a what we call a pillable error, an error in also applying the law. You have the error of applying the law, and you have error of weighing evidence. Let's talk about applying the law. The district court errs in applying the law when it misinterprets the law, applies the wrong law, or ignores the law. The district court has no discretion on legal issues. The appellate court reviews rulings on matters of law de novo with little deference to the district court's ruling. I'm going to read the first sentence here where it says the district court errs in applying the law when it misinterprets the law, applies the wrong law, or ignores the law. So we have misinterpretation of the law. We have the wrongful application of the law, and when they outright ignore a law. And this is called a appealable error. All right. Now let's talk about misinterpretation of law. The first one. Well, maybe uh, the judge is misinterpreting the law, uh, maybe not interpreting congressional's or Congress intent when that law was created. Maybe misinterpreting that way. Maybe they are misinterpreting a judge's decision or a judge's opinion, maybe from a higher court. Let's talk also about applying the law wrong. I mean, I think that's pretty simple. Maybe giving you a harsher charge that is not in um, is not in which the transaction that you may have been involved in may have not been warranted of that kind of charge. Maybe they've applied, a law that is no longer in use. These are just some hypotheticals. And ignores the law. Well, maybe you are presenting court case law that they may be ignoring. Maybe you're presenting statute or codes, which is very rare they ignore those. They may rule on it as far as giving an opinion what they believe the Congress intent was to be based on the Constitution, of course, what should be based on the Constitution. It's not always like that, as we all know. So those are your three ways that makes it a pillable error when it comes to applying error in applying law. You have misinterpretation, the wrong application or the wrong law being applied, and we have where they outright ignore it. And I'm sure some of us who tend to go in and speak for ourselves, um, we tend to get a lot of maybe the laws we present to the court ignored. And some of it has to do with our incompetency on how it should be presented based on court rules and procedures. Some of it is truly a flex of a muscle by the judge who is supposed to be a referee. And, they can do that. And sometimes maybe you are using the wrong law in the wrong court. And again, I talked about that in part one. Okay. Let's see here. Number two, Number one was error in applying law, and number two is error in weighing evidence. The fact finder, either the jury or in a non-jury trial, which is the judge, errs when it clearly misevaluates the evidence. Right. Misevaluation and handling of the evidence. Maybe the judge allowed evidence that was not supposed to be allowed into the court. Or maybe he or she didn't allow evidence that was supposed to be allowed in the court that could have affected the outcome of that issue that's at stake. That not only in its effect of the outcome was relevant to the transaction and the circumstances of the case. So that's a way that the evidence was weighted in error. Number three and four is error in deciding, which is number three, error in deciding whether fact issue exists. And number four is abuse of discretion. Error in deciding whether the fact issue exists. It says the district court errs when it fails to recognize that a genuine dispute of material facts exists. A fact issue exists when a party has introduced some evidence on an issue, but has not proved the issue as a matter of law. Repeat this again. A fact issue exists when a party has introduced some evidence on an issue, but has not proved the issue as a matter of law. Number one of this, number one of number three. So I'm just gonna say A, not to confuse you. So 3A, if there is a fact issue. So it says if there is a material fact issue, the court cannot grant a motion for summary judgment or a motion of judgment as a matter of law, but instead must submit the contested issue to the jury. So there's a fact that's an issue. It can't submit a summary judgment, which is based on the matter of law. There's an issue of facts that must be heard by a jury or in jury trial. Summary judgment as a matter of law, you won't get that if there's a fact issue or a fact that is of issue. What if B, if there is no fact issue, no material facts are in dispute, then the facts are established conclusively. When there is no contested issue to submit to the jury, the district court must grant a motion for summary judgment or a motion for a matter of law. So there's any time where there is a issue regarding a fact, that fact will not be granted a summary judgment as a matter of law. Now, there's no fact issue, you can get a summary judgment. So always remember, there's still an issue of the facts. If you're going to ask for a summary judgment, you may not want to include that issue, because the judge is going to take and inform you that matter that's still an issue, which a lot of times the defendants will raise the argument, or even plaintiffs, that certain facts are still an issue and the court shouldn't rule on it until a jury has weighed in on these facts and examined these issues to determine if there, of course, is an issue or no issue. All right, abuse of discretion is the most difficult type of error to reverse on appeal. So when you say a judge abused their discretion, it's really hard to prove that. Now, there's ways you can, but it's definitely challenging. Generally, a district court's abuses its discretion when it renders a decision that is arbitrary and unreasonable. Appellate courts have formulated various tests for determining when to find that this has occurred. And of course, it gives us some case law here on this particular ruling. It says ruling on motion for new trial is reversible as abuse of discretion if the court did not identify or apply correct legal standard, or if court applied correct standard but applying to facts was illogical, but application, to facts was illogical, implausible, or without inferential support. I think that's pretty simple. Let's see here, preserving error. And when we object, what are we doing, ladies and gentlemen? We are preserving the errors. When we make an objection, we are preserving the errors. Okay, so preserving an error is more the subject of case law than of the rules. Federal Rule of Civil Procedure 51 and Federal Rule of Evidence 103A deal explicitly with the preservation of error and the consequences of not objecting. Typically, ladies and gentlemen, if you are in a state, most states will have the federal rules kind of like here in South Carolina. There's a Rule 402. And everyone knows that's one of my favorite rules. But there's also a federal Rule 402. So they are typically the federal rule or the state court rules are harmonious with the federal rules. And they typically don't range so much as being different. You have some states with its own unique number, but majority of the states I've seen all have the numbers that are in harmony with the federal court. But of course, check your state just to make sure and read the rule. Then it says Federal Rule of Civil Procedure 51 provides that unless the error is plain and affects substantial rights, a party may claim error based on the giving of or refusal to give an instruction to the jury. So if the judge failed to provide instruction to the jury, if the party objected on the record before the jury was instructed, so if you objected on the record before the jury was instructed, Federal Rule 103A sets out the circumstances in which error may be predicated on evidentiary rulings. Of course, we know you must assert a valid objection. You must give proper support to your objection. You cannot object and not have grounds or support to persuade the judge why your objection should be sustained and not overruled. So the party should support his objection with evidence when necessary. So if you have evidence, maybe case law, that may support your objection. It must be timely. The party must object within the time frame described by rules and case law. See here. The party seeking to preserve error must get the court to make a ruling on the objection and make a record of the ruling either by written order or an open court. So when you make an objection, make sure you not only get on the transcript, but possibly, definitely get a written order of that if you're not able to get a copy of the transcript. And for when you are preserving and making this objection, be prepared. Be prepared to well, I take that back. Not be prepared, but make sure that you you inform the judge you like to have a ruling on that objection. Are they going to sustain it, or are they going to overrule your objection? Okay, because that does go on the record. So your failure to preserve error, that's a general rule. Appellate courts refuse to consider an issue raised for the first time on appeal. So listen, if you try to go to an appeal court and you did not raise an issue in the lower court, they can't see it, and you cannot raise a new issue at the appellant level. It has to be on record somewhere where they can see that you objected. Okay? If you don't, chances are you didn't preserve the record. They cannot see their objection, and they will not hear that issue if you were to raise it. Let's see here. There's some exceptions to this, though. It says there are a number of exceptions to the rule prohibiting appellate review of errors not preserved by objection. So, what are these exceptions where, if I don't object, it is still I can still get the relief or apply for some review at the appellate court level? Well, the exceptions are plain error. So there's a plain error, right? A manifest error doctrine. The manifest error doctrine. It says the appellate courts excuse the failure to make an objection in any of the following instances. 1. When the issue is a pure question of law and refusal to consider it will result in miscarriage of justice. It sounds like a constitutional challenge to me, or could be a constitutional challenge. I have a federal question. I would like to question the constitutionality of this law, and failing to do so will be a miscarriage of justice, because if it can't be determined to be constitutional and it's allowed to continue, maybe this so-called law that is being allowed to continue is in fact unconstitutional, and us, or not being able to question or validate its constitutionality can be considered an error, or a manifest error, for better words. It says, number 2, when the interest of substantial justice is at stake. I think the interest of substantial justice is at stake. Is this, it affects me personally, but not only me personally, it also affects everyone else at large. Not everyone else, but those maybe who are or who have been or come in contact with or dealt with or transacted with this particular party. Maybe the party is a government entity. I always use this as an example. Um, I wouldn't say it's an example for, um, I don't know if it's really a manifest error, but I definitely can say the interest of substantial justice is at stake, and substantial justice means your substantial rights as we the people. Uh, that was at stake when the COVID-19 shot was being administered by the executive branch and forcing it upon private parties, not government bodies, mainly private individuals and corporations were forcing it, right? That was a substantial justice at stake, which ultimately was ruled to be unconstitutional. And that only, I believe, federal employees or medical employees were the only ones truly subject to that order. Number three is when there was no opportunity to object to an order at the time it was issued, or four, when an issue or new issue arises because of change in law while appeal is pending. That's very rare. Let's talk about number one again, the pure question of law. When an issue presents a pure question of law, the appellate court can consider it even though no objection was made. It's good to know. Uh, Number one, subpart A, we're talking about subject matter jurisdiction here. A party can raise an error in subject matter jurisdiction for the first time on appeal. So there's no subject matter jurisdiction. You can raise that issue on appeal. The timeliness of that objection does not matter because subject matter jurisdiction can never be waived. Then we have B here of statutory interpretation. A party can raise an argument for the first time on appeal if it is a pure issue of statutory interpretation that is fully argued in the briefs. So there's a issue of how the law is being interpreted. And that's the pure question of law. Let's look at substantial justice. So it says A, integrity of trial. Party can raise an error for the first time on appeal if the error seriously affects the fairness, integrity, or public reputation of a judicial proceeding. B, evidentiary rulings. A party can raise an error in an evidentiary ruling for the first time on appeal. The party can show that one, there are exceptional circumstances. Two, these circumstances affect substantial rights. And three, a miscarriage of justice will result if the plain error doctrine is not applied. And then we have C, jury charge. Party can challenge the jury charge for the first time on appeal if the party can show that an error in the charge affected substantial rights. Then we have, of course, the third one was the no opportunity to object. Maybe they hit you with the I don't say another word, I'm gonna hold you in contempt. And that could be one, right? I didn't have an opportunity. If I spoke again, he was gonna hold me in contempt. So I was afraid of my life. Didn't want to say nothing. And then of course the change of law. And again, rare, but that's one way we can still raise an issue in an appellate court on that particular error. Um, okay. Making sure I didn't miss out on anything of importance here. I don't think so. So we're going to end that part 2 of today's podcast pretty shorter than usual for sure. Shorter than usual. Well, that's good for me. I get to count some sheep jumping over the moon tonight, you know. But I do thank you guys for tuning in as always. Living Equity Podcast. Follow me on Living Equity on Instagram, TikTok, and on YouTube at Living Equity. And you can follow me also on Facebook as well. If you have any questions, feel free to drop a comment. I definitely like to talk to my audience. Don't get too detailed, please. Let's keep it short and sweet. And also, we accept donations as well. If you want me to continue to read these nice books off my shelf and, bless the masses